Good afternoon. Good afternoon.
Good afternoon.
Okay, good afternoon. Nice to see
Good
you.
afternoon, Professor. Yeah, nice to see you. I think that we have some minutes to start this opening seminar, and now we are waiting for other colleagues, especially for Dr. Liss, who is the first presenter. Now I seen a little bit strange pictogram because there is a pictogram about that I cannot share the screen, but I hope that we can change this function somehow. I hope so. I hope the best. I checked something. Sorry, it's only a test.
Okay.
I don't know whether you've heard me. Good afternoon, everyone.
Yeah, good afternoon. We can see you.
Okay, I can see you and I can hear you.
Okay, I think, can you see my presentation?
Yeah.
Yes, we can.
Okay, thank you so much.
Yes.
And now I close it. Thank you so much. And
Good afternoon.
Good afternoon, Dr. Liss. And good afternoon, Dr. Chirsky as well. And I think everything is perfect. Now the team is completed by Hungarian and Polish members. Taking into account that there can be other colleagues, I would like to express my gratitude that we could gather here. All members of the Polish-Hungarian research platform, Legal Protection of Farmer research team, research group. This is our second opening panel, opening seminar. Some weeks ago, we started to somehow summarize our research, and now we are about to detail the given fields of our research. First of all, I would like to call Dr. Liss to deliver his presentation connected to the historical development of Polish law. Dr. Liss, the screen is yours. Dr. Liss, excuse me, maybe do you want to share? Okay.
1 minute.
Okay, excuse me.
If I may suggest something, can we switch the role of the Dr. Liz to the presenter mode? Please right click on the surname of Dr. Liz and change his role to the presenter.
Oh, yes.
Okay, thank you very much.
Yes. I have a presentation.
Yes, definitely we can see it.
Agricultural legislation has undergone significant evolution. The greatest development of agricultural legislation and legal doctrine occurred at the beginning of the 19th century. During this period, the evolution of two models of agricultural law regulation became the fundamental and still relevant approach to agricultural legislation. One model, known as the Roman model, particularly applied in France, Italy, and Spain, emphasizes civil regulation with all its principles. This model refers to regulations of private law. The other model, referred to as the Germanic model in literature, focuses on the regulation of agricultural legal relations through administrative and legal means. Initially, a significant factor was the process of peasant enfranchisement in the 19th century. In the Polish territories, the period of enfranchisement occurred between 1807 and 1864. Although at the turn of the 19th and 20th centuries, there were three different legal systems in force in the Polish territories, in all the partitions, there was a set of predominantly administrative provisions related to peasant enfranchisement, colonization, later agricultural reforms, land consolidation, and various forms of regulating the technical aspects of agricultural production. The period of peasant enfranchisement was characterized by the utilization of public law instruments to implement the agricultural policies of that time. The reborn Polish state faced the need to repeal the existing regulations of the partitioning states and, above all, to issue numerous new laws shaping the agricultural system. After Poland regained independence in 1918, the following legislative regulations were enacted. 1. Resolution of the Legislative Sejm of July 10, 1919, on the principles of agrarian reform. 2. Act of July 15, 1920, on the implementation of agrarian reform. 3. Act of December 28, 1925, on the implementation of agrarian reform. The legislation related to agrarian reform during the interwar period focused on the following issues. 1. Partitioning of large agricultural estates, known as manors, and the creation of new peasant farms or their enlargement through land redistribution. 2. Enfranchisement of long-term land tenants who were not granted ownership rights. 3. Abolition of servitudes. 4. Elimination of common land ownership. The 1921 Constitution specifically addressed land ownership, stating in Article 91 that land could not be subject to unrestricted free trading and that the state would regulate such transactions. During this time, the greatest importance was attributed to the 1925 Law on Agrarian Reform. It abolished certain oppressive legal relationships in the agricultural system, such as servitudes, organized common land ownership, and enfranchised small agricultural leaseholders. The process of land consolidation, known as komasacha, was also continued. When discussing the legal regulations in the field of agrarian law during the interwar period, it is worth noting that after the Act on the Implementation of Agrarian Reform in 1925 came into force, the Minister of Agrarian Reforms established the Commission for the Organization of Agrarian Legislation, chaired by the Ladislaw Leopold Jaworski. The result of its work was the Draft Agrarian Code, which was published in 1928. The Ladislaw Leopold Jaworski approached the draft with three main theses. 1. The Agrarian Code should have the character of public law regulation since its primary objective is to restructure of the agricultural sector by the state for the public benefit. 2. The Agrarian Code should consist of both tangible and formal parts. 3. The scope of codification should also include the introduction of supplementary provisions to agrarian legislation. The draft of the Agrarian Code authored by the Ladislaw Leopold Jaworski exhibits the following characteristics. 1. It is a code of administrative law. 2. It is the central legal act of agrarian law. 3. It contains the fundamental institutions of agrarian law. 4. It is not complete, and this incompleteness was intentional. 5. It not only codifies the existing regulations but also replaces them and creates new ones. 6. It is oriented towards the long-term effects of its regulations. 7. It is based on economic rather than political considerations. 8. It is designed in such a way as to minimize the need for frequent amendments. After World War II, Poland introduced a socialist system, which can be divided into two main subperiods. 1. The subperiod of accelerated implementation of the socialist system, modified after Stalin's death in March 1953. 2. The subperiod of functioning of the socialist state. New regulations in line with the Germanic model appeared in Poland along with the new ideology after World War II. The regulation of agrarian legal relations, particularly intervention in the sphere of property law, was carried out through administrative means. This process began with the decree of the Polish Committee of National Liberation of September 6, 1944, on the implementation of agrarian reform, Journal of Laws of 1945, number 3, item 13, as amended, followed by laws and executive regulations issued by the Minister of Agriculture concerning social relations in the agricultural sector. The period from 1945 to 1955, characterized by accelerated collectivization in agriculture, enhanced and expanded this new approach even further. Agrarian law was intended to serve as a legal instrument not only for agrarian reform but also for the comprehensive socialist restructuring of the agricultural system in Poland. This new approach and the social function of agrarian law had a significant impact on the nature and scope of this branch of law. 1. The former, narrow concept of agrarian law was abandoned, and a new concept of agrarian law was permanently introduced into doctrine. 2. Agrarian law ceased to be treated as a branch of administrative law but was viewed as a comprehensive branch of law including norms of civil and administrative legal nature, unified by their agricultural field of influence. 3. The emergence and formation of new institutions specific to the agrarian law, unknown in traditional branches of law, began to be recognized. 4. Some softening in the policy of rural socialization, which occurred after 1956, led to a broadening of the scope of agrarian legal regulation beyond the restructuring of the agricultural system. It encompassed the entire set of norms governing the structural spatial background of agriculture, the organization of the market of agricultural products and the production processes in agriculture. In the following years, until 1980, we observed the so-called indirect socialism, which is characterized by a return to civil law regulations in the field of agricultural law. Active policies sought to prevent the fragmentation of individual farms. Land transactions during this period were based on a civil law model combined with administrative control over territorial norms. The mandatory delivery requirements were quantitatively reduced, and legal regulations in this regard were replaced by contractual agreements. The institutions regulated in the Civil Code Act of April 23, 1964, relating to real estate trading, abolition of co-ownership, leasing, contracting agreements, life tenancy, and special legal regime of inheritance of agricultural farms, took on a new shape. In the 1980s, an attempt was made to maintain some balance between civil law and administrative regulations. The aforementioned institutions related to real estate transactions were further improved while new regulations emerged, such as water law, protection of agricultural and forest lands, land exchange and consolidation, and spatial planning. Equality between sectors in agriculture, such as commodity trading, was developed. The principles and rules governing land management are a function of the state system. They differ in liberal, socialist, and communist states. Consequently, the ownership structure depends on the legal system prevailing in a given country. The system transformation necessitated a departure from strict legal administrative regulations in agricultural law and led to the implementation of Roman law principles within the adopted social market economy adopted after 1989. This period brought about the establishment of government agricultural agencies, privatization, restructuring, and liberalization of agricultural land transactions. Above all, the integration aspirations with the European Union became apparent. From a very formal standpoint, it is worth emphasizing that EU regulations are becoming increasingly structured, encompassing a wide range of legal acts and regulations essential for specific areas of the common agricultural policy. The view that EU agricultural law is increasingly regulatory in nature and less interventionist seems justified. However, in Poland and other EU member states, EU agricultural legislation has become the dominant source of agricultural law.
Thank you very much.
Ede, you are on mute.
Thank you so much. I thought that you can read from my mouth, but of course, it's the original way. It's maybe better in this case. Dear colleagues, thank you so much for the presentation of Dr. Lis. Thanks a lot. And now I would like to continue with my presentation, taking into account the concept of our planned monograph. That is, as in the first part, Dr. Lis could be the author and presenting these dogmatics concerning the Code of Agriculture. And in the second part, we would like to focus on agricultural lands and holdings acquisition, including the contribution of Dr. Horniak, Dr. Strala, and mine contribution. Moment, and I share the PPT. I hope that you can see it. Thank you so much for your reaction. As to my presentation, I would like to focus on the international aspects of acquisition of agricultural lands. I think that this aspect of agricultural land acquisition is not as obvious. Therefore, it includes some new ideas and approaches. However, what does it mean, international aspects of land acquisition? This is a kind of summary of my ideas. First of all, I would like to draw your attention on the Food and Agriculture Organization of the United Nations voluntary guidelines on the responsible governance of tenure of land, fisheries, and forest in the context of national food security. This document was adopted in 2012. Of course, in a later part of my presentation, I'm going to detail it. As a kind of second interesting aspect of international law connected to land acquisition, it is the regional human rights regimes. As to Poland and Hungary, of course, the European system it can be interesting and essential, especially the European Convention on Human Rights and its human rights regime connected to the European Court of Human Rights is cardinal. As a third aspect of land acquisition at international level, it can be the international investment law regimes. This area of law, it's quite fragmented, that there are numerous international investment agreements. In this part of my presentation, I would like to focus especially on the EU's new treaties with investment provisions. I think that this phenomenon has a quite difficult title, but it's not a coincidence. And of course, I'm going to detail it in later part of my presentation. And last but not least, I have to note EU law as well, because it can be considered also as a kind of international law. It's first emphasizing that these fields of international law, they were previously subject of my research activity and the research activity of my colleagues. Therefore, I would like to draw your attention to some previous research as to the Food and Agriculture Organization's voluntary guideline. I made some research and I published these basics in 2019. As to the regional human rights regime and land acquisition, I would like to draw your attention to George Marinkás research. Some elements were published in 2022. However, you can find other publications of the author. As to the international investment law regimes, some basics of this topic, they were published in 2022 in co-authorships with Balint Kovács, and some specific elements, they were published in 2018. However, it's worth noticing that there are so many new events, documents in connection with this field that in my chapter I can refresh, and I can draw your attention to developments as to this field. And as to EU law, in the present presentation, I do not deal with this topic because I consider it as a separate field of law, and I would like to present it next time in connection with the Open Scientific Seminar, the third one, if I'm right, in next month, therefore in July. Okay, as to this topic, I had to determine a kind of hypothesis, from which point of view I would like to assess these fields of international law. And as a kind of basics, I focused on the basic pillars, elemental pillars of the Polish and Hungarian land law. Taking into account one of our previous research, which was published in 2022, my conclusion was that the Polish and Hungarian land law, it's relatively or quite strict in comparison with other countries' legislation of this region. For example, as to the Slovak legislation or the Czech or maybe the Croatian one or the Romanian one. These national legislations, that is Polish and Hungarian regulation, it's quite strict. And, this kind of strict regulation demands a kind of freedom or flexibility as to the international frameworks. Therefore, as a kind of working hypothesis, taking into account these characteristics of the Polish and Hungarian regulation as to international affairs, it is important for both countries to maintain their regulatory freedom at international level to the fullest extent possible. Therefore, in the later part of my presentation, I'm going to base my assessments on this hypothesis, that is, it is the interest of Poland and Hungary to somehow keep and develop this flexibility of the international law. First of all, as I previously mentioned, I would like to present the voluntary guideline of the UN agency. Here you can see some important features of this voluntary guideline. This is first international soft law document on land acquisitions. All words are quite important. What does it mean that this is the first international document? It is a kind of self-determination of the voluntary guideline. And it is true that it's not typical that an international agency deals with acquisition and national land law of countries, sovereign countries, because it's typically considered as a kind of inner affairs of a given country. Another important aspect that this voluntary guideline is a kind of soft law document. What does it mean, soft law document? It's not a binding, it's not a compulsory document. Taking into account this characteristic of the voluntary guideline, maybe we can say that in this sense it's not an important document. Why to deal with this document? But in reality, I would like to emphasize that this voluntary guideline is also cited by institutions of the European Union in other land law documents, and I would like to present these EU documents in my later presentation next time as to the third open seminar. Therefore, this is an important aspect. Another important aspect that sometimes the Court of Justice of the EU also refers, especially in connection with reasoning of a given judgment, to these kinds of soft law documents. Therefore, maybe not directly, but indirectly, these kind of documents, they can become part of a quite hard judgment of the Court of Justice of the EU. Therefore, in my opinion, it's quite important to deal with these kinds of documents as well. Okay, as a kind of next step, I would like to continue my presentation about the content of this voluntary guideline. In the center, in the focus of this voluntary guideline, we can find the concept of food security. It's obvious because we can find the reference to the food security concept in the title of the document. However, it's also important and essential to refer to the fact that partly or indirectly, another important concept was a kind of pillar of this document, and this is food sovereignty. Therefore, in the core of the voluntary guideline, we can find the food security, and the main instrument is implementing the concept in the land acquisition is the so-called responsible investment. Therefore, according to this document, the responsible investment itself, a quite important way how to achieve food security, maybe indirectly and or partly food sovereignty as well. Responsible investment, what does it mean? An important feature of this responsible investment is connected to the interests of the rural communities. Therefore, a responsible investment, we can say that serve also the interests of the rural communities itself. But what does it mean, rural communities? In a given sense, maybe we can think that rural communities, it's connected to, for example, indigenous peoples' interest. And as to the UN document, I think this approach is quite clear and it's correct. However, if we would like to implement this concept to the EU's legislation, the situation is not as clear. At the beginning of 1990s, I think that the concept of rural communities, it was something similar in the EU, especially determined by the Cork Declaration, the first one, because the concept of this Cork Declaration reflected to the Council of Europe concept of rural communities. However, this concept was changed in the second version of the declaration, the Cork Declaration. It was adopted some years ago, and as to the concept of this modern declaration, we can say that the inclusive society changed the previously indigenous community concept, and this new concept does not demand this indigenous characteristic of the communities. I previously presented this change in one of my previous publication published in 2019. I also drew the attention to the situation how this change happened. Therefore, I would like to summarize this point, that there is a kind of tension maybe between the concept of rural communities of the voluntary guideline and the new approach of the rural communities of the EU's declaration Cork 2.0. Another important feature of this responsible investment, that transparency is quite important, which transparency includes the traceability of the ownership backgrounds as well. Why is it important? It is important for Poland and Hungary because since some restrictions on the acquisition of land by legal person exist both in Polish and Hungarian land law, the voluntary guideline may help to justify the maintenance of these provisions of national law. Therefore, as a kind of summary, this soft law documents, it can be especially important maybe in the reasoning in front of a potential case in connection with the national legislation of Poland and Hungary. The next aspect of the international law concerning land acquisition connected to the regional human rights regime. There are numerous cases in front of the European Court of Human Rights. One of my colleagues, Dr. Marinkás, however, systematized these cases. He determined 4 subcategories. In the first category, there are compensation-related cases where the earlier proprietors or their heirs' interests clashed with the interest of third parties who acquired the property in good faith. That is one group, or the first group of the typical cases. Another group of these cases connected to land consolidation issues. The third one connected deprivation of property or the restriction of the use of property based on environmental protection consideration. And last but not least, there is a fourth group as well, connected the inheriting agricultural lands, which pursue to prevent the agricultural land to be plotted into small pieces. Now, I do not want to go into details in connection with these issues, but I would like to focus on the affected human rights of the European Convention on Human Rights. And there are especially 2 rights in these cases. The one of them, this is the right to a fair trial, and the second one, it is the right to property. As to the adoption of new national land law, especially this right to property can be interesting. That is, this right does not guarantee the right to acquire property. What does it mean? Right to property typically protect the existing ownership, and there is a kind of freedom for the countries, how to regulate the moment of acquisition of a new property. As to this regime, I have to emphasize, highlight that since no one has a substantive right to acquire property, individual countries have great freedom to develop their own acquisition rules. If we simply take the European Convention on Human Rights regime as a starting point, of course, we as EU's member states, we also have to consider other aspects of law. As to international investment laws regimes, as I previously mentioned, I would like to focus first first on the EU's new treaties with investment provisions. Acquisition of agricultural lands is typically a foreign direct investment category. They are FDI, typically, as I previously mentioned. As to the EU, of course, we have to separate two categories of these investments. In the first group, we can find investments coming from EU member states, which are subjected to the law of the host state and also EU law. That is, we have to deal with these investments via EU law and, of course, the national law, the given national law itself. I would like to deal with this category, especially in my next Open Scientific Seminar. However, there is a kind of second group of this category. They are the investments coming from third countries, and they are subject of the international investment agreement. After the Lisbon Treaty, EU gained exclusive competence on foreign direct investment as part of the common commercial policy. In this sense, maybe our first reaction could be that the member state, they do not have any opportunity to somehow affect this agreement. But in reality, the situation is different. Why? Taking into account the colorfulness of the treaties of the EU, that is, these treaties typically also regulate, in addition to the foreign direct investment, non-foreign direct investments and dispute settlement regulation. Therefore, in reality, when there is a treaty in front of the Council or other fora of the European Union, the member states, they have a relatively big freedom to express their opinions and to affect the development of these agreements. As to this agreements, it's worth emphasizing that there are so many types of these agreements. Before the Lisbon Treaty, the member states, they had, and partly they have, 1,400 bilateral investment treaties. As to the Lisbon development. Now the European Union and the member states, they are about to change this previous regime and to adopt new treaties. However, there are so many treaties connected to Canada, South Korea, Singapore, and so on and so on, and their names vary widely. For example, you can see investment agreement, free trade agreement, trade and investment partnership. Not only the names of these treaties vary, but also the way how cross-border land acquisition exists regulated in these treaties. Maybe the first one is not a kind of surprise for you, that they are regulated as part of investment, but we can find cross-border issues also in some treaties regulated in connection with services and or freedom of establishment. As I previously said, the situation is quite colorful. Some Central European countries, for example, Poland, Hungary, however, they have reservations about closing their markets to cross-border land acquisition in the previously concluded and signed treaties. Therefore, as a kind of conclusion, we can say that, first of all, it's quite important to somehow assess and to understand the main provisions of this kind of regulation. And in addition to this, it's very important that Poland and Hungary also express their reservations regarding future treaty with investment provisions, so that the protection of their land acquisition regimes remains close. That was the first presentation of my ideas of these issues, and of course I would like to go into details in my chapter of the monograph concerning this aspect of international law. Thank you for listening. I was honored for your attention. Dear colleagues, thank you so much. And now I would like to invite the next presenter connected to acquisition of agricultural lands. I would like to call Dr. Hornyak to present the Hungarian legislation, as far as I know, focusing on legal persons. I hope that in a certain sense I could introduce some elements of this issue. Dear Doctor, the screen is yours.
Thank you very much. Now I try to show my presentation. I'm not sure that I can make it. Okay, I think now you can see my presentation.
Yes, definitely.
Thank you very much. So, thank you for this opportunity, dear professors, dear colleagues. Now, in this open scientific seminar, I would like to speak about the acquisition of ownership of agricultural lands by legal entities in Hungary. And first of all, I would like to speak about the general rules of ownership acquisition right. And in Hungary, we can say that ownership of land may be acquired by domestic natural persons. It means the Hungarian natural persons, and of course the EU nationals, with one condition. This condition is that he or she has to be a farmer if he or she would like to acquire a normal amount of the agricultural land. What does it mean, normal amount? It means this 300 hectares land, which is the land acquisition limit in Hungary. But a Hungarian natural person and an EU national can also acquire the ownership of land in Hungary if he or she is not a farmer. But in this case, the main rule is that only maximum 1 hectare can he or she acquire. And this 1 hectare maximum means that the land he already possessed, together with the land what he wants to acquire in this case, together means this maximum 1 hectare. But there are other exemptions. A close relative of the person transferring ownership of the land can also acquire 300 hectares of the land if he is not a farmer. So this is an exemption from the main rule. And there are another exemption. It means that a domestic natural person or an EU national who is not a farmer can also more land acquire than 1 hectare in the case when the acquisition of land is in the way for a recreational use. What does it mean, this acquisition of land for recreational use? It shall mean the acquisition by domestic natural persons or EU nationals who are other than farmers of land appertaining to a municipal government or a Budapest district government and designated for such purpose by means of a resolution not exceeding 1 hectare in size for the purpose of use by the acquiring party and to collect its proceeds up to an extent not exceeding his own needs and those of his relatives living in the same household. So this is the general rules for the acquisition of ownership of land. And the other question is that who cannot acquire the ownership of land in the general rules? It means the third country natural persons who are not an EU nationals cannot acquire the land. Of course, foreign states, including their provinces, local authorities, and the bodies can also not acquire the land in Hungary. And the general rule is that legal persons cannot acquire the ownership of agricultural land in Hungary. But there are some exemptions in the Land Transaction Act. So it means that the main rule is that legal persons cannot acquire land, but there are some legal persons who can acquire the ownership of agricultural land. But I would like to highlight that the general restriction on legal persons applies only to the acquisition of ownership of land and not to the use of land. But in this research, I don't deal with the rules of the use of land. So now I can see that the general restrictions for the acquisition of ownership of land means that legal persons cannot acquire the ownership of land in Hungary. And now we can see the exemptions. It means that legal persons can acquire the ownership of land, and these legal persons who can acquire the ownership of the land, we can classify into 2 groups. First group is, it means the legal person who can acquire the land ownership without restriction, and it is only the Hungarian state. And the other group is the legal persons who can acquire the ownership of the agricultural land with restrictions. And here we can see 3 categories. It means only these 3 legal entities can acquire the ownership of the land with restrictions. But the restrictions are very different by each categories. And as you can see, these 3 legal persons are a listed church and its internal legal entities. The second is the mortgage loan company, and the third is the municipal government of the community where the land is located. And now I would like to speak about a little bit detail for these restrictions in each legal entities. First, legal entity who can acquire the acquisition, who can acquire the ownership of the agricultural land in Hungary is a listed church or its internal legal entities. And here are the special conditions in connection with the title of the legal transaction. So it means that what kind of contract or agreement can a listed church acquire the ownership? It means that a listed church can only with a testamentary disposition or under a maintenance or life annuity agreement or an agreement for providing care or a gift contract acquire the ownership of the land, and for the construction and expansion of cemeteries by way of transfer and by way of exchange of existing land holdings. So these contracts and agreements, with these contracts and agreements can a listed church and its internal legal entities acquire the ownership of land. The second legal entity who can acquire the ownership of the land is the mortgage loan company. And the restrictions we can see in the Act on mortgage loan companies and mortgage bonds. And there are 2 conditions, and only with both of these conditions can a mortgage loan company acquire an agricultural land in Hungary. And these conditions are 2 different conditions. First is in connection with the time frame, and the second is the title of the legal transaction. So a mortgage loan company can acquire land only for a temporary period of not more than 1 year following the date of acquisition, and only by way of liquidation or enforcement procedure. And there are some detailed rules for this legal entity. It means if the mortgage loan company is unable to sell the land it has acquired within 1 year of the date of acquisition, the land shall be transferred to the Hungarian state and shall then be given to the National Land Fund. And the Land Fund management body shall pay to the mortgage loan company the collateral value of the land within 90 days from the date when the transfer of title to the state is recorded in the real estate register. And there are some other rule for this mortgage loan company, and it means that a mortgage loan companies operating as branch offices may not acquire ownership in arable land in Hungary. And the third legal entity in Hungary who can acquire the ownership of agricultural land is the municipal government of the community where the land is located. And the restriction by this legal entity is in connection with the purpose. So it means that a municipal government of the community can only acquire the ownership of land for the implementation of public benefit employment programs and social land programs and for urban development purposes. Furthermore, if the land is protected site of local importance for the purpose protection of the land under the Act on Protection of the Natural Environment. So as we can see, the restrictions between the three legal entities who can acquire the ownership of land in Hungary is very different. And now I would like to speak about some special cases, and after that, some exemptions for the legal entities who can acquire the ownership of land in Hungary. What does it mean in my interpretation, this special case category? I mean that there are some title of legal transactions, and in the case of these legal transactions, only special subjects can acquire the ownership of the land. And in numerous cases, these legal entities are the subject of these transactions. So we can see two categories for the special cases. First is is in connection with the gift contract. And it means that an agricultural land may be transferred with a gift contract only to close relatives, and from the legal entities, only a listed church or its internal legal entities, or a municipal government, or to the state. So I mean this special, so there are the special circle of subjects. And the other case is the land transfer with a maintenance and life annuity agreement, and in this case can acquire the ownership of land only a close relative, and from the legal entities only a listed church and a municipal government and the state. And in my interpretation, the exemptions for these legal entities means that in the Land Transaction Act are some general rules for the land transaction. And in the previous Open Scientific Seminar, I already mentioned it and I already spoke about it. And now I would like to highlight that there are some exemptions from the general rules of the Land Transaction Act for the legal entities. One of the general rules in the Land Transaction Act is that the acquiring party has to make some statements when he would like to acquire the ownership of land. The statements are that he undertakes that not to permit third-party use of the land and to use the land himself, and in that context to fulfill the obligation of land use, and agrees not to use the land for other purposes for a period of 5 years from the time of acquisition. So this is the general rule, and this rule does not apply to the legal persons who can acquire the ownership of land. So it means an exemption from the general rule, but also it is a facilitation for the legal entity who can acquire the ownership of land. Another facilitation is that the land acquisition limit shall not apply to the legal persons who can acquire the ownership of land. And there are some other exemptions and other facilitations for these legal entities. And as we can see on the slide, it's about the preemption right. And this preemption right shall not apply to some cases. And I would like to highlight only the relevant categories. Relevant, it means that relevant for this topic. So the acquiring, the acquisition of ownership of legal entities. So it means that the preemption right shall not apply to any sales transaction for the purpose what I already mentioned before, by the municipal government of the community. The other category when the preemption right shall not apply is to acquisition of land by the Hungarian state, and the preemption right shall not apply to any transfer made to a listed church or its internal legal entities for the implementation or expansion of a cemetery. And there are some other facilitations for these legal entities. It means that the approval by the agricultural administration body is not required for the state acquisitions. And from the other side, it's also not required for the alienation of land owned by the state or by any municipal government. And this approval is also not required for acquisitions of legal entities who can acquire the ownership of land with restrictions. It means the municipal government, the listed church, and the mortgage loan company. I would like to speak about a little bit the time before the Land Transaction Act, because before to the entry into force of the Land Transaction Act, a group of legal persons may have acquired land at certain times, which may no longer acquire land under the Land Transaction Act. But this group of legal persons, of course, did not lose their previously acquired land after the entry into force of the Land Transaction Act. But now we can see in the Land Transaction Act that legal persons established by way of division, separation, merger, reorganization may not acquire the ownership of land acquired by its predecessor as provided for in the Act on Arable Land, or acquired by its predecessor before the time of entry into force of the Act on Arable Land. And this act is the former Land Transaction Act from 1994. And I highlighted a phrase of this rule. It can be also an exemption for one of the legal entity. It means that this rule not including listed churches or their internal legal entities. And as a conclusion, I would like to speak about the purpose of these general rules. It means that in general, a legal person cannot acquire the ownership of land. And according to Tamás Andréka, who is the permanent secretary of the Ministry of the Hungarian Ministry of Agriculture, he said that the aim would be to prevent the creation of an uncontrollable complex chain of ownership, which would run counter to the objective of preserving the population retention capacity of the countryside, as it would not be possible to control the respect of the land possession limit and other acquisition conditions. And joining to the presentation of Professor Szilágyi, I can highlight that the key word here is maybe the transparency. Yes, maybe the transparency. And I am very curious about the Polish regulation in this topic. And thank you very much for your kind attention.
Dear Dr. Hornyak, thank you so much for your presentation. I think we have to emphasize, however, that this Hungarian legislation is subject of an infringement procedure, which was initiated after the end of the after 2014. At that time, that was the end of our derogation period. However, this infringement procedure is in front of the Court of Justice of the EU, but it was not finished or closed. Therefore, it is a pending one. It's worth noticing that these rules of legal persons prohibition, it is the reason of our specific succession rules as well, taking into account that via legal persons we cannot transfer, the agricultural lands, or only in a prohibited or restricted way. Therefore, it's quite essential part of the Hungarian legislation, these rules. And now I would like to call our Polish colleague, Dr. Strala, to deliver his presentation about the situation in Poland. Dear doctor, the screen is yours.
Thank you very much, dear professor. I would like to ask whether my presentation can be seen.
Yes, definitely. Yeah, it is.
Okay.
It's great.
Thank you very much. Dear professor, dear colleagues, dear participants and our attendees to our seminar, thank you very much once again. Today, topic of my presentation is the acquisition of agricultural lands by legal entities in Poland. And I think it's interesting in comparisons between the Hungary system presented by Dr. Horniak and the system that exists in Poland. To start with the absolutely fundamental regulation, the Article 2A paragraph 1 of the law from the 2003, amended in 2016, deals with the absolutely fundamental rule that the purchaser of the agricultural land in Poland may only be a physical person, an individual farmer especially. The definition of the individual farmer can be seen on this first slide of the presentation, and it was in detail described in the previous, in the first seminar of ours. So I would like to go through the presentation next. It was only to the order of the presentation. Theoretically speaking, I believe that the possibilities for acquiring land, agricultural land by the legal entities, can be divided into five ideas or 5 ways, 5 institutions, legal institutions that led to possibility for acquiring this kind of land. So the first way is to acquire non-agricultural land. It may sound curiously, but it will be described in the next slide. The second way is to acquiring the land, agricultural land, out of the scope of the law of 2003. And the third and fourth way is the exemptions, ones based on the objects of the law, and the second, the subject of the law. And the fifth one, and the most important, because of the effect of the system of agricultural land and its acquisition in Poland, is the authority permit. In other words, the approval from the administration body. To start with this first interesting sounding, acquiring non-agricultural land. As we go through the regulations of this law from the 2003, we find the legal definition of the agricultural real estate or agricultural land. And There is a relation with the definition from the Civil Code, and once again, it was described in details on the seminar 1, but it is highlighted in red color of the font. It is with the exclusion of the real estate located in the areas designated in spatial development plans for non-agricultural purposes. So even if this land that can provide crops is in the boundaries of the cities or in the plans of spatial development for non-rural purposes, objectives, it can be still bought because this is not agricultural land as far as we concern this regulation, and the prohibition for acquiring the agricultural land by legal entities is only in this law. So as far as we go outside of the definition of the agricultural land, it is a possibility to buy agricultural land also by the legal entities. There is a problem because there is a obligation for the communities to prepare these spatial development plans, but many of them simply doesn't have anyone of them. So the regulations about the spatial development provide the institution of regulating the purposes of the land, of the all lands, not only the agricultural lands. It is done in the form of the administrative decision of the authorities, and in this decision, the purposes of the land is regulated. So there is a debate whether, in the case when we don't have these special development plans, if we have this decision that is the equivalent of this plan, whether this decision can be decisive in the way that this law from the 2003 regulates the prohibition of the acquiring agricultural land. In other words, if there is no special development plan, whether we can acquire land without any prohibition, any restrictions, or we need a decision from the authorities about the objectives, about the purposes of the land, this administrative decision, and if this decision there is no agricultural purposes, we then can acquire the agricultural land. It is still debated, and there is, I believe, there is no one decisive view on this topic. So the second way to acquire land by the legal entities is to go outside of the scope of the law of 2003. When we look at the articles 1A, 1B, and YC of this regulation, you can see that some kinds of the agricultural land simply they are not regulated by this law and choose not regulated by this prohibition for acquiring agricultural land by the legal entities. There are numerous regulations. This translation of this act is preliminary. It will be revised, but I would like to show you the complexity of this regulation and to look at the first paragraph of the Article 1A. This law doesn't deal with the lands included in the agricultural property stock of the state treasury. It means that if this is the real estate, special real estate owned by the state and included in the sum of assets of the agricultural lands owned by the state, it simply can be acquired without any restrictions. However, in the separate statute about the selling land from this agricultural property stock of the state treasury, in fact, from the 2016 and so on, there is a prohibition to sell any land, agricultural land, larger than 2 hectares. So, in fact, this is a very limited effect on the market. The second rule is, for example, that the law doesn't deal with the lands of acreage less than 0.3 hectares. And once again, this exemption is a minor if you concern the effect on the market. Another exemption deals with the internal roads or the ponds. If you let me, I will know. I won't go in details through this all of these exemptions because they are of minor importance for the market. If we look at the another statute, in fact, it is comprehensive and it's compatible with the regulation from 2003. I mean the law from the 2016 14th of April. You can see that everyone can acquire built-up agricultural land with area not larger than half of the hectare, and the other exemption deals with the agricultural lands in this administrative decision mentioned before that are issued in the situation where we lack the special development plan. It is called decisions on land development and zoning. So this is the exemption I talked about earlier. In fact, under these regulations, they are very limited, especially with the area, when the area of the land is concerned, possibility for legal entities to buy agricultural land in Poland. But there are several object-based exemptions. And the first of all, agricultural land lesser than 1 hectare can be acquired by legal entities. Another thing, and this is a similarity between the Poland and the Hungary law, as a result of inheritance and legacy, it can be acquired by the legal entities. And as you can see, there are some very special, you may say, one-of-a-kind exemptions in this law. And highlighted in red, I believe this is the most important and of most importance for the market. And look at the point 10. This is the abolition of joint ownership, division of joint property, and the division of inheritance. This is one way of the exemption that can be used to acquire agricultural land. And the other, also mentioned in a presentation by Dr. Horniak, the division, transformation, and the merger of commercial companies. So when one company merge with another, or there is a takeover, one company by another, it can be this new company can acquire the agricultural land owned by its legal predecessors. So this is another exemptions go through from the mining law, and once again, this is the minor of minor importance. The subject-based exemptions, you can see, in fact, the subject-based exemptions deals mainly with the public law institutions. So the state, the local communities, regions, and other government units can acquire agricultural land. Companies, but if you go through the details, only companies with the shares of the, or the rights that are owned by the once again public institutions. So in fact, the private companies under commercial law can't use this exemption. In fact, the only private law institutions that can acquire agricultural land without further restrictions are the legal persons acting on the regulations of the relationship between the state and the churches. As you can see, there are no limitations to cemeteries. Churches and its legal entities, for example, parishes, dioceses, and others, can acquire agricultural land without further restrictions. In fact, when the regulation was introduced in 2016, there was a discussion whether this new regulation whether it will be the impulse or the cause for establishing new churches, new church legal entities, only to buy agricultural land. We have a couple of years of this regulation in force, and I don't believe that there are any new churches registered only to buy agricultural land. However, it is in Poland. It is quite easy to register a new denominational legal entity because we need only 100 members or the people who will sign the declaration of the establishment of the new church with full private law capacity. So probably the 18 years old or older. There was such danger, but from this 8 years of this regulation, we don't see increase in the number of the legal entities of the church and its activities in the field of the agricultural land. However, in some ways, probably legal persons of the denominational entities can be used for acquiring agricultural land, but it is important in Poland to we need to emphasize that according to Polish law and the jurisprudence of the Polish Supreme Court, when we do a contract, when we sign a contract between the churches and the other persons, we need to go in accordance with the regulations of the internal law. So, for example, we can use a denominational legal entity as a legal vehicle to buy agricultural land and try, for example, to get a right to use, preemptive right from the church to, for example, to buy agricultural land after the 5 years period, and so on. But in some churches, it will be most difficult because the internal regulations prohibits, for example, the selling of the land. I will go in details in the part of the book about this regulation. I would like here to mention it. And the other subject-based exemptions, for example, deals with the agricultural production cooperative. It is a way of the organizing by the individual farmers to form some kind of the legal entity, but not every land can be acquired in this case. Only in the special cases. So in fact, this is only of minor importance for the agricultural market. As far as other ways, as you can see from these four ways of the of acquiring land without this prohibition dealing with the individual farmers. In fact, only very small lands, very small plots can be acquired, or in very special cases, very few legal entities, especially public law legal entities, can acquire agricultural land. So what is the way to acquire agricultural land by the typical, for example, corporation? In fact, the only way is to achieve an authority permit, an approval from the administrative body. And what are the prerequisites of this permit? This permit is regulated in the complex paragraphs of this law. However, the main regulation is here in the point 1. It can be read that the seller of the agricultural property should file a motion for achieving approval, a consent from the authority. But what are the prerequisites for this motion? Of course, it was not possible to say the agricultural land, for example, to the individuals. It is regulated further. For example, there need to be an announcement, a public announcement through the portal run by the authorities. The second prerequisite, the land must be used for the agricultural activities. And the third and most important one, I believe, the acquisition of agricultural real estate will not result in an excessive concentration of agricultural land. And this wording of the statute can be interpreted in very different ways. For example, whether the 300 hectares is excessive concentration or it is only a concentration of agricultural land. There is a strong line of the view of the doctrine of many lawyers in Poland that it should be regulated exactly what amount of the agricultural land can be treated as an excessive concentration of agricultural land. For now, it is probably left to the administrative courts, which will control the authorities, the procedure for especially refusing giving consent, to interpret it and to give indication how to treat this prerequisite. So if I would like to go to the summary. So generally, agricultural land in Poland can be acquired only by individual farmer. There are numerous exemptions, subject-based exemptions, object-based exemptions, very complex regulation. But when you summarize all of them, they are all of minor importance, of no importance for the, in fact, for the market. Generally speaking, the only private law legal entities that can acquire agricultural land with the widest exemption are the legal persons of the churches. And for other private law organizations, the main possibility for acquiring agricultural land, the land with the importance, for example, that is not a very small plot. This is the way through the permission from the authorities of the state. But how can you evidence that this acquiring will not result in an excessive concentration of agricultural land is a very difficult question in each procedure. Thank you very much for your kind attention.
Doctor, thank you so much for your contribution. I think we can assess the Polish legislation is similarly difficult and complex as the Hungarian ones. It's quite interesting, and I think it supports my previous position that the Polish and Hungarian land law regulation, it's similarly strict in this sense. And I think it can be similarly interesting at EU law level. Okay. And now I think we have to change our perspective. And now we should focus on other activities, not with acquisition of agricultural land, but for example, as to the cultivation and agriculture activities and maybe the agriculture products themselves. First of all, I would like to call Professor Adamus to deliver his presentation. Dear Professor, the screen is yours.
Thank you very much. I am trying to get control over the screen, so give me just 5 seconds to complete this task.
Okay. Of course, you have this time.
Could you help me? What shall I press to be in the control of the screen?
I think in the middle of your screen,
Yes.
there is a button. On my screen, it is a red button. And
Yes.
yeah, and you should click on
Press
this.
it.
Yeah, and after
Okay.
that you have to choose the window in the middle of the menu up. Yeah.
Thank you very much.
Yes,
Thank you
it's
for your
better.
help. Thank you for your patience. And I hope it's visible everything on your screens.
Yes, definitely.
I am more than happy to continue my presentation about farmers' protection in civil law in Poland. I'd like to present today some proposals connected with regulation of the farming contract in the Polish code. I'd like to present you results of my research on this topic and ask you for any critical comments, ask for suggestions on issues that have been omitted, and request for any questions about the matter I'd like to present today. I'm fastening my seatbelt just to start. Okay, general aspects of farming contract. In the first issue, I'd like to present you 4 points. I think they are initial points to the discussion. First, the choice of the proper law, essentially negotiation of the contract, duration of the contract, and place of performance of the contract. I think that if the farmer is a natural person, the possibility of choosing another law than Polish governing the contract should be limited. I think that this clause is very popular in consumers' relations, and I think we could copy this idea to the farming contract in order to give a better legal protection for consumers who are natural persons. And I think this idea should be discussed very carefully. The next issue, the next point is essentially negotiation of the contract. I think that it should be highlighted that farmer is obliged to deliver stipulated goods unless he is prevented by objective circumstances beyond his control, in particular agrobiological, hydrological, and weather, to produce and deliver to the contractor a specified quantity of agricultural products of a certain type. I think it's very important because the practice in Poland is the following. If the farmer is not in a position to deliver the goods, he has to pay contractual penalties. And I think that clear definition of the farming contract will help to avoid such situations in the future. So I think that this careful definition of the farming contract is very crucial in the aspect of the protection of the farmers. I think that the regulation of the price to be paid to the farmer should be a little bit flexible. First of all, I'd like to stress that the price may be also stipulated by indicating the grounds for its determination in future. But I think it's not a very controversial proposal. But I think that the great role in protection of farmers is for the next proposal. I think that de lege ferenda, it should be stipulated that the remuneration for the farmer should not be less than the sum of the direct targeted costs incurred by the farmer. In present practice, there is a very often situation that the costs are much higher than income for the farmer, and such a situation is the source of insolvency of many agricultural producers in Poland. I think that this should be carefully discussed, and I think that such proposal could help to avoid insolvency in future. However, there are many factors which are very important in this matter, and they should be discussed very carefully. And I think this proposal could be somehow to be discussed a little more carefully. I think that also in the matter of essential negotiation of the contract, it should be a very flexible regulation of quantity of agricultural products. They could be indicated by the area from which the products are to be harvested. They could be indicated by minimum quantity or by maximum quantity of the products. They could be described for one production cycle of agricultural products or as a whole production of the agricultural holding. The following issue is about new list of additional benefits for the farmer. In fact, in the farming contract, there are very often stipulated additional benefits for the farmer. They are of very different types, and I think that the existing list in the civil code is quite outdated, and I think we should propose another list of additional benefits. And for example, my proposals are the following. Ensuring that the farmer can acquire certain means of production with deferred payment. I think it's a very important issue because agricultural activity is very expensive, demands a lot of cost, and deferred payment is a very big economic help for farmers in order to buy special means of production and fertilizers and so on. I think that another additional benefit could be in this shape: conclusion of an insurance contract for agricultural products for the benefit of a farmer. I think the next additional benefit could be the following: granting sureties of payment, guarantees for the purchase of means of production. And the last one, I think, is the same like existing in the civil code. As the demands for quality of food is very high nowadays, I think that the next proposal is also very important and should be discussed very carefully. I think that the new regulation of a farming contract should stipulate that contractor can control the agricultural production. He can ask the farmer to demonstrate the legality and conformity of the means of production techniques used by the farmer, and the contractor should be entitled to supervise and control the performance of the cultivation contract by the farmer. Of course, it should be given to the parties how to regulate this problem in details, but of course, the legislation should show the problem of the control of the contractor. Duration of the farming contract should be very flexible one. I think that there could be many types of definition of duration of the cultivation contract, and to present some of them, a contract can be concluded for a specific cycle or cycles of agricultural production. It's also possible to use a construction of a framework agreement and executive contracts to a framework agreement. And of course, it can be also a clause for automatic renewal of the contract for the next stage of production. The place of performance of the farming contract, I think this proposal is not very outstanding. The place of performance of farmers should be the agricultural holding, unless otherwise stipulated in the contract. However, in some cases, the situation could be more complicated. And I think, in my opinion, it should be introduced a special regulation in case the place of performance is not the agricultural holding, and the transport is to be carried out at the expense and risk of the farmer. In such a situation, I think that contractor who, regardless of the reason, refuses to accept the fulfillment of the contract shall be obliged to reimburse the transport cost incurred by the farmer. And in order to keep the balance between the parties, I think that it should be added unless the farmer has unduly prevented the contractor from examining the goods on his agricultural holding. I think this regulation should be not possible to be changed by the parties if the farmer is a natural person. Less favorable contractual provisions should be null and void. If the object of the contract is divisible, it should be enforced the following rule, I think. In such a case, the contractor may not refuse to accept partial performance unless otherwise stipulated for important reasons. And the next stage, the next aspects of the farming contract is failure to perform a farming contract. I'd like to highlight two special situations in this respect. First, in case of delayed start of performance. If a farmer is so late in starting production or individual parts thereof that it's unlikely that he will be able to produce and deliver them within the agreed time, the contractor should have the following right. He may, without setting on additional period, withdraw from the contract before the expiry of the deadline for delivery of the object of cultivation. And in case of another wrongful fulfillment of the contract, if in the course of production of the object of cultivation, it turns out that the farmer produces this object in a defective or contrary way to the law or the contract, the contractor may, at the first stage, call on the farmer to change the manner of performance by setting the farmer a special deadline for this purpose, and on the second stage, withdraw from the contract after the ineffective expiry of the deadline. I think that such regulations are present in some other types of the contracts. So for Polish lawyer, they could be very similar to other regulation. And the next big problem with farming contract is the problem of not being in a position to fulfill the contract because of external reasons. And the devil is in details, so I think that we should discuss it very carefully. And in the first stage, I think that we can propose the following regulation. If the farmer's performance has become impossible as a result of circumstances for which none of the parties is responsible, the farmer may not claim the remuneration. I think it's quite obvious regulation or rule. and if he has already received it, he is obliged to return it in accordance with the provisions of unjust enrichment. Of course, it's just the first stage of the problem. On the other stages, we should develop the problem, because this is a very complex aspect of relations between the parties. I think that we could introduce the following rule. The obligation to return does not apply to properly used advances and additional benefits previously received from the contractor. In this regulation, I think we can catch the balance between the position of the farmer and of the contractor, and if the advances or benefits are used by the farmer in a proper way, I think the farmer should not be obliged to return such advances and benefits. It's a change into the present situation of the farmer, so I think that this proposal should be very carefully discussed before offering this to the legislator. And on the third stage, I'd like to underline that the farmer shall not be required to pay the equivalent of the benefits properly used or proportional parts thereof. And in order to protect the contractor, this not shall apply to advances and benefits used by the farmer after he became aware that his performance is impossible. And in this respect, I think that we could show the proper balance between the farmer position and the position of the contractor. However, it requires a very careful discussion in order to be sure that this proportion of balance is in a very good position. Another issue is situation if performance of the contract is only partially impossible, and if the farmer's performance has become possible only partially, the farmer shall lose the right to the part of the consideration, and if he has already received it, he shall be obliged to reimburse it in accordance with the provisions of unjust enrichment. And the obligation to reimburse does not apply to proportionally occurred, correctly used, and previously received advances and additional benefits. However, there is a game changer if the contractor may, if the object of the contract is indivisible, the contractor may withdraw from the contract. I think it's quite obvious proposal in this respect. To finish this problem, I think that the farmer shall have priority over the contractor for agricultural production insurance if is there any in a situation of the conflict, and if the farmer is a natural person, the less favorable contractual provisions shall be null and void. I think that it's also a very important issue in this respect. The next part of problems is connected with civil liability of the farmer. And in first words, I'd like to suggest the following regulation. The farmer is liable to the contractor under the warranty if the products have a defect, to the extent the defect is not a consequence of circumstances for which none of the parties is responsible. And in the event of defects in the subject of contracting, the contractor may exercise the following rights: make a proportional reduction in the price or withdraw from the contract. Of course, it's on the general level, and in some cases it should be put in a quite larger picture in order to understand the idea of this regulation. So if only a part of the object of contracting is defective and can be separated from a part free from defects, the contractor's rights to withdraw from the contract is limited to the defective part. I think it's also quite obvious proposal, and of course it should be a definition of appropriate use of price as presented in the next slide. And if the contractor may not exercise the mentioned above rights, if the farmer replaces the defective contracting objects with free from defects or removes the defects, the exercise of withdrawing of a contract should not be allowed to the contractor. And the other regulation connected with this matter is the situation of the case when contractor loses his rights under the warranty. It happens if he has not examined the subject of cultivation in time and in the manner adopted for such items, and has not immediately notified the farmer about the defect. I think that this regulation is similar to existing ones, so I think it is rather an undisputable one comparing to other proposals. The loss of rights under warranty is excluded if the farmer knew about the defect or assured the contractor that the defect did not exist. It's also a copy of existing provisions in other kinds of contracts. A farmer shall be liable under the warranty for defects also in the case where the reduction to the subject of cultivation took place in the manner specified by the contractor, unless the farmer, despite exercising due diligence, could not detect the defectiveness of a production method, or the contractor, despite drawing the farmer's attention to the above defects, insisted on the agricultural production method specified by him. So in this regulation is also a kind of finding a balance between the parties of the contract. I hope it could be accepted by both parties, such a proposal in this respect. And the last problem connected with liability is the liability of the contractor or the other party of the contract in the case of defects in the means of production supplied to the farmer. The contractor should be under the regulation of the sale contract. It's not important to repeat the regulation of the civil code, and we can address to the other regulation concerning the contract of sale. And the next very important issue is connected with withdrawal from the farming contract. And in this respect, the party who withdraws from the contract is obliged to return to the other party everything he has received under the contract, and the other party is obliged to accept it. The party who withdraws from the contract may demand not only the return of what has provided, and if return is not possible, to pay the value, but also, on general terms, compensation for damage resulting from non-performance of the obligation. The contractor may require this farmer to release him from his obligations, especially in connection with additional benefits. I think that this provision is based on general rules on civil law in case of withdrawal from the contract, and I think that it should be added another rule connected with withdrawal from the contract. Due to the fact if the object of production, the contractor has made a declaration of withdrawal from the contract or price reduction, he may claim compensation only for the damage he suffered as a result of concluding the contract, and if damage was a result of circumstances for which the farmer is solely responsible. In particular, he may demand reimbursement of the cost of concluding the contract, the cost of collection, transport, storage, and storage insurance. This does not prejudice the provisions on the obligation to redress damage on general principles. I think that this regulation also will allow to keep a proper balance between the parties in case of some serious problems. And I think the next important regulation, limitation of claims, mutual claims of the farmer and the contractor expire after 2 years from the date of performance by the farmer, and if the producer's performance has not been fulfilled from the date on which it should have been fulfilled. I think it's also very important issue. It's important to make the terms a bit shorter than in general rules, and I think it's similar to the present regulation in the case of a farming contract. If you have any questions, if you have any suggestions, I am open to any of your questions, and I hope to ask you ask your questions if you have any to me.
Dear Professor, thank you so much for your presentation. And as you mentioned, that is the time to comment or to pop questions. Maybe somebody.
I would have two questions, which is because it is not perfectly clear to me that the provisions mentioned by you are sector-specific provisions, or do they generally flow from general provisions and they also apply to the agricultural contracts, or do all these provisions are formulated in a specific chapter of your civil code, or did you interpret all of these rules because they are formulated generally and they also apply to the agricultural and farming contract?
Thank you for your question. Shall I explain that in Polish Civil Code we have some parts of it? There is a general part of the Civil Code, and in the third book of the Civil Code we have obligations, and obligations are divided into two parts as well. The general provisions on obligations, and in the second part there are typical rules for typical kinds of contracts.
Mhm.
And I think that my proposal is to discuss very carefully how to amend existing rules in the Civil Code in the second part of the third book of the Civil Code connected with the special kind of contract. So I think that these provisions should be addressed to the specific kind of contract. It's the farming contract, and these rules should not be to be used in other types of the contract unless the law addresses these rules to the special purposes. And I think that there are some very important issues connected with this problem, because there are many changes in economic and social environment. So the existing rules are quite outdated. And if we could discuss the changes in this regulation, I think we could help farmers and contractors in concluding better relationships on the legal way.
Thank you. So when we try to apply the general provisions to the agricultural sector, there are not enough. There are no enough protective pillars for the farmers, because the general rules are not meant to be applied to the agricultural sector, and these general provisions do not take into account the specific features of agricultural production. So if I'm not mistaken, this is your approach, that we should, to be more exact, the Polish legislation should introduce more sector-specific rules that take into account the specific features of agricultural production and the specific situation of agricultural producers.
If we talk about a farming contract, this is a relationship with a very large number of stages. The regulation of the wills of the parties is one aspect of this situation, And if we come to the legal regulation, we have some kinds of special rules. First of all, the civil rules on general aspects of obligation law. And on the second hand, we have special rules addressed to this special kind of the contract. So I'm talking only about the rules which are only designed for the farming contracts, not to the general contracts at all.
Okay, I understand. Thank you.
Thank you.
Okay, thank you so much for your questions and also for the feedbacks, for the answers. And now I would like to call our colleague, Dr. Czirski, to give his presentation connected to a quite similar topic, however.
Professor Adamus, can you please close the presentation? Oh, thank you.
Thank you.
Can you see my presentation?
Definitely, it's okay.
Thank you. So thank you very much for the opportunity. As you can see in this presentation, I will speak about civil and commercial law instruments, but also my next presentation will also be about civil and commercial law instruments and the contract law provisions that were presented by Professor Adamus in the Polish legal system will be presented as regards Hungary during my next presentation. So this presentation will have two parts. On the one hand, I will talk about the legal forms of conducting agricultural activity, and in the second part, I will deal with the principle of the freedom of agricultural contracts, and this will be a more general analysis, and my next presentation will attempt to delve into the sector-specific contract law provisions. So, first of all, the legal forms of conducting agricultural activity. As regards the topic, we can say that there are several forms, and I think the basic distinction that should be drawn up is whether the farmer aims to produce alone or together with other producers within any type of producer organization. We should also mention that based on different legal areas, there are different terminus technicus for the legal forms, and however, I think that irrespective of these different terms and expressions, what the most important is whether the given producer or producers have enough bargaining power when they try to sell their agricultural products. I would like to touch upon the new Family Farms Act of Hungary, which has three sui generis agricultural law categories concerning the forms of conducting agricultural activity. The first one is the primary agricultural producer, the second one is the family farm of primary agricultural producers, and the third one is the family agricultural company. As I see that these notions are relevant from two perspectives. One of them is taxation, and the second one is the acquisition of agricultural land, because these legal forms have certain preemptive and pre-lease rights when it comes to the acquisition of agricultural lands. Nevertheless, the basic operational forms of conducting agricultural activity or any other activity have remained intact by the Family Farms Act. So these these notions are of relevance to taxation and the acquisition of agricultural lands. From a commercial law and a tax law perspective, we can say that the basic forms are the following. Agricultural producers can be individual entrepreneurs, or they can conduct agricultural production in any company form that is regulated in the civil code. There are 4 different kinds of company types: general partnership, limited liability company, and public limited company. Furthermore, agricultural production can also be conducted in the form of a cooperative. What is relevant that a primary agricultural producer can produce on his own or as part of a family farm of primary agricultural producers. However, there is an incompatibility rule not to apply in parallel legal forms that overlap each other from the viewpoint of tax law, which declares that an agricultural producer who conducts agricultural production in according to the legal rules applicable to the so-called primary agricultural producers cannot be an individual entrepreneur. Therefore, who is engaged in agricultural production can choose to perform this economic activity as either individual entrepreneur or primary agricultural producers. Not to mention that the most favorable form of conducting agricultural activity from a tax law perspective is the form of primary agricultural producers, because the whole Family Farms Act and in related to this, the whole personal income, the Act on Personal Income Tax was construed in order to create favorable taxation positions for agricultural producers, and one of the legal forms is the primary agricultural producers and those who are registered as primary agricultural producers. On the other hand, when it comes to the perspective of competition law, we apply completely different terms when establishing privileges for the market participants. However, it is necessary to draw a distinction between our national law and EU law, because in Hungary, the general competition law exemption from the prohibition of anti-competitive agreements is formulated regardless of any organizational form of the respective producers. And this exemption can apply and can be connected and is connected to the fact that the subject matter of the agreement is an agricultural product. So it is irrelevant whether the producers who are parties to the agreement, in which way do they conduct and in which legal form they conduct the agricultural activity. So on the other hand, there are the vertical exemptions laid down by Section 25 of the Agricultural Markets Act, which requires a legally recognized interbranch organization. That is to say, when it comes to vertical relations, to enjoy the exemption of the competition law provisions, the producers shall be legally recognized, and it is not irrelevant in which way they conduct agricultural activity, because they have to be part of the respective interbranch organization to get exempted from the prohibition of the anti-competitive agreements. On the contrary, in EU law, as regards horizontal cooperation, there are certain exemptions from the prohibition of anti-competitive agreements that only apply to legally recognized producer organizations, and there are also exemptions that have no other criteria. It is enough to be engaged in agricultural production, and also non-recognized farmers associations can be exempted. Concerning vertical agreements, the situation is the same like in Hungary. In conclusion, the organizational form in which agricultural production is performed has no relevance. In business transactions, when producers step up as sellers, the legal form in which they conduct agricultural activity does not matter, and it is irrelevant whether the production takes place as primary agricultural producers, individual entrepreneur, or in a form of a limited liability company, or for example, a cooperative. Neither company types nor taxation forms determine and influence the protection provided to farmers by private law, including competition law, when negotiating sales contracts. However, when it comes to competition regulation, there are some exemptions, and the applicability of certain competition law exemptions would not require legally recognized structures in some cases. However, in my opinion, we should distinguish two different layers: the production and the marketing phase, and the form in which agricultural production is carried out do not limit the safeguards introduced by sector-specific contract law and competition law provisions. However, curtailing the freedom of agricultural contracts has no connection with the legal form in which agricultural production is realized, which I think is of high importance and is necessary for the protection of agricultural producers. As to the second part of my presentation, I will speak about the principle of the freedom of agricultural contracts. When the directive in the European Union was introduced on unfair trading practices, there was a German author who said that with the adoption of sector-specific rules in agriculture, the freedom of contract was sacrificed and had been further restricted by interest-driven policies. I see that the constraints that influence the freedom of contract come from two directions. First, there are sectoral contract law provisions in the Hungarian Civil Code and in other acts. And second, there are trade regulation provisions with public enforceability. However, in my later presentations, you will see that also there are certain sectoral contract law provisions which have public enforceability, which is, I think, quite rare in civil law relations, and I think it to a high extent restricts the freedom of agricultural contracts, but it does so for the sake of the protection of agricultural farmers. Both of these notions have an impact on the possible terms and conditions stipulated by contracting parties, because, of course, when there is public enforceability behind certain contractual provisions, the contracting parties will necessarily follow these rules. The third subject of my research, which will be presented in the fourth and fifth open scientific seminars, is competition law. However, these exemptions do not influence the parties' freedom of contract, but rather alleviate the situation of producers who aim to countervail the bargaining power of buyers. So while these contract law provisions are take a different approach, because they try to introduce further protection for farmers, competition law exemptions do the same but from a different perspective, because they do not introduce protective pillars but alleviate and make it easier for farmers to combine forces in order to countervail the bargaining power of their buyers. There are three sub-principles to the freedom of contract. First, that persons can decide whether they would like to enter into a contract at all. Second, they can choose those persons with whom they would like to enter into a contract. And third, contracting parties are free to determine the terms of conditions of their contract. And the freedom of agricultural contracts is limited and restricted as regards the third sub-principle, that is to say, the certain sector-specific provisions limit the content of the contract. So, in general, both farmers and the buyers can decide whether they would like to enter into a contract at all and with whom they would like to enter into a contract. However, the content of the contract will be restricted and limited by civil law provisions. Certain general remarks are worth mentioning. For example, that I identify the following aspects and terms of contracts that are formulated taking into account the special characteristics of agricultural production. So there are two types of agricultural contracts regulated expressis verbis in the Hungarian Civil Code, and the following aspects are touched by these sectoral rules. You can see there is a list of obligatory elements in the contract. The provisions also touch upon the period of completion, the minimum period for the contract, the entry into force of the contract, the deadline for payment. There are tightened rules for late payment. There are some alleviations to the quantity to be delivered. There are some specific provisions for the reimbursement of the costs of services provided by the buyer to the seller. We can see some exclusion from liability, and the method of price determination is also included among these specific provisions. However, I have to correct myself, because these aspects are not only regulated in the Hungarian Civil Code, but also there are some provisions that have been codified in the Agricultural Markets Act, and the provisions in the Agricultural Markets Act and in the Hungarian Civil Code complement each other. So the provisions that are included in the Agricultural Markets Act come with public enforceability, which try to complement the Hungarian Civil Code with a kind of additional protection for farmers. What is unusual, and I have already mentioned it, that certain civil contract law provisions are supported by public enforceability. That is to say, certain authorities and the agricultural authorities can impose a fine when they find that the provision has not, the civil law provision was not followed. So it's quite interesting, and I call this the public enforceability, because the parties are not free to deviate from these provisions, and also the agricultural authority, the National Food Chain Safety Office, in most cases, can impose a fine on the contracting party if the provision is not followed. Third, there are certain agricultural products where formal constraints are laid down in the form of obligatory written contracts. It is not a unique requirement at all, since there are several contracts that shall be in writing, for example, a sales contract for real estate. But there are subsectors of agricultural production where it is required to conclude the contract in writing. And for certain contract law provisions are also enforced by public authorities, having competence to impose fines on non-compliant contracting parties. Conclusions that which is very important, that the freedom of contract related to agricultural products is indeed more limited than in general, and added to this is the enforceability of certain private rules under public law with government agencies, with the possible imposition of fines, which emphasizes the additional protection of producers. And I think these regulations serve the interests of producers and are quite necessary. And I think that that to include more binding provisions would be a too strict intervention to the private autonomy of contracting parties. But all in all, the protection of producers in general terms is quite well served in Hungarian law. Thank you very much for the attention.
Dr. Csirske, thank you so much for your contribution. And now that is high time to pop questions, if you intend to do that. If you want, of course, it's not compulsory element. I would like to express, but that please do not forget that during the creation, writing of your chapter, all of us have to focus on assessment of the present legislation and practice, and to determine best practices, which can be important for the legislator, and to determine the lega ferenda proposals. Today, of course, we could hear some of them, these proposals, and they are quite a precious part of our research. I previously noticed in a comment in the chat box that please do not forget that our next month, that is July, we have not only one but two open seminars. Therefore, July it can be quite active month for us. And now I repeat my question. That is whether any comments to each other or not. If not, in this case, there is the high time to close the present seminar. Dear colleagues, thank you so much for your contribution on behalf of the organizers, that is the Institute of Justice in Warsaw, and their program. This is the Polish-Hungarian Research Platform. Of course, we can keep in touch via email and in this form of the open seminar. Thanks a lot and have a nice evening.
Thank you very much, Professor. The same to you.
Thanks a lot.
Thank you.
Bye.
Bye.
Goodbye. Thank you.
Thank you.